You're listening to the Study Legal English podcast, helping lawyers and law students become fluent in legal English. For more information, visit studylegalenglish.com. Hello and welcome to the Study Legal English podcast. I'm your host Louise, and today, my lucky listeners, you are going to be hearing the second part of my interview with Sarah Fox, construction lawyer and contract specialist. If you haven't already listened to part 1, I really recommend that you do. That is episode 96.1, where we introduce her concept of the 500-word contract. We also talk about the essentials that need to go into a contract, and we also talk about her star review checklist, which you can use to review your own contracts to see if they are indeed any good. This week in this episode, we are looking at liquidated damages clauses, what they are, and what are some of the myths around them. I'd like to say thank you to Wala Mohammed. I hope I've pronounced your name correctly there, Wala. She posted the question about liquidated damages on my Facebook group, and Wala sounds so dedicated to legal English. She said that she's been teaching herself over the past 2 years, and what's more, she's a survivor of COVID-19. Alhamdulillah. She said in the group that she is used to achieving her goals no matter what. So I hope that today what we cover in today's episode helps you on your journey, Wala, and I hope you get the answer to your question. In this episode, we also talk about what you can do today to start improving your contracts, as well as some resources which may inspire you to use visuals in your contracts. For Podcast Lite members and Pro members, you get your transcripts over on the Study Legal English website. And for Pro members, you've got loads of extra material, including 2 bonus episodes, one discussing the vocabulary used in this episode, and one which is a summary, which is helpful if you are in a rush, you haven't got time to listen to the full episode at the moment. Go ahead, listen to the summary, and then when you've got a bit of time, you can listen to the episode in full. So let's go. So one of the things that I wanted to talk about specifically is liquidated damages, because someone on my Study Legal English Facebook group asked a question like, can you talk a little bit about liquidated damages? And what I most like to do is to ask the experts rather than explain myself. And so I thought, maybe Sarah can talk about this a little bit.
Yeah.
And you've got an absolutely brilliant article on your blog which kind of busts the myths around, the common myths about liquidated damages. You know, there's a lot of, if you search for liquidated damages on the internet, you're going to come across a lot of contradictory stuff. You know, oh, you can't do this. Oh, you can do this. And, you know, you just don't know what the truth is. So can you explain, first of all, what are liquidated damages? And then maybe talk through a couple of the things that lawyers need to watch out for when they're drafting or when they're presented with a liquidated damages clause.
So it's a great question, and it's one of my favourite workshop topics, because I get to bust a load of mess because people have kind of heard snippets, and those snippets have sunk in without actually being sense checked before they've been lodged in their brains. So effectively, liquidated damages are a sum set out in a contract. Now, it can be a fixed sum, so it could be a certain amount, so it could be £100, or it could be a sum per period, so it could be £1,000 per day, or it could even be a percentage of the contract price, so 1% of the contract price per week, that are payable if the other part, if a party breaches a particular part of the contract. Now, typically in the construction sector, we have liquidated damages for delayed completion. So if the project is late, then, for example, on a nuclear power plant, you could have liquidated damages running at £1 million per day, which kind of essentially is meant to reflect the loss of income from not being able to produce that power. You can have it when you go to a hotel, and if you check into a hotel bedroom, often it will say if you smoke in this non-smoking bedroom, we will charge you £100 for breaching your agreement not to smoke in this room. And you can also have it for terminating a contract. So if you change your mind on a contract and you want to end it early and you don't want all the goods that you've ordered, you could have a contract term that said if you cancel midway through, you will pay us half the contract price and we'll both walk away. So there's all sorts of different ways that you can use liquidated damages in contracts. But a lot of myths built up. There was a case back in 1915, which was published just on the outbreak of the First World War. So it didn't get a lot of attention at the time, but has been lodged in a lot of people's memories. It was a really well-structured case, well argued. The judgment is great. However, things have moved on. And the case was Dunlop and Pneumatic Tyre Company, 1915, went to the House of Lords. It was to do with distributing Dunlop tyres in a garage company. So it looked at the whole concept of liquidated damages, but a series of cases in the last 105 years have kind of turned those sort of myths on their head somewhat. And essentially the courts have said that the fact you go into a hotel room and smoke, it doesn't matter that it doesn't cost £100 to open the windows and waft a pillow around and get rid of the smell. If you breach your contract and you did it knowingly, then you just have to pay the fine. So it's essentially saying, unless it's a ridiculous amount. So the cases basically came back to, unless it's extravagant and unconscionable compared to the greatest loss that could possibly be suffered, then you have to pay it. So £100 to leave a room empty or get it cleaned or get the smoke out of there is not a ridiculous amount. If it was £1 million, then it would be extravagant if they wouldn't be able to recover it. And it all came back to a car parking case, which went to the Supreme Court, where somebody was charged £85 for overstaying a 2-hour free car parking allowance. And he stayed 2 hours and 43 minutes or something, but argued that actually the next person wouldn't have paid any money to come in. So how could they possibly charge him £85? And they just said, well, actually, the whole purpose of this is to stop people, effectively commuters, parking at 9 o'clock in the morning, coming back at 5 o'clock and bunging the car park up. The idea of the car park is to keep a general flow of people popping in for a paper, pint of milk, packet of bacon or whatever they want, and then bobbing off rather than hanging around. So there was a commercial imperative. So it wasn't just fictional, it wasn't make-believe, it wasn't a deterrent, it wasn't an extravagant amount, because a local authority fine could be up to £100 if you didn't pay it immediately. So they said it's not a ridiculous amount of money. It is a lot of money, but it's not ridiculous. And you breached your part of the contract. The contract was quite clear on the sign. You overstay, you're welcome, you pay the money. You had a choice. You could have left in the 2-hour period. Because you didn't, you get charged. End of. And in fact, the Supreme Court actually said, we don't even think that the doctrine of penalties, which is an English law doctrine which allowed people to try and overturn liquidated damages, has any real value in modern commercial contracting. It's a relic. It started in the banking industry, ended up in commercial contracts, probably by accident. We think it has no place in modern society. And frankly, it sounded like the judges were saying, can you stop arguing the point? Because you know what? You're now just arguing over the minutiae. And if you didn't want to have that clause in your contract, you should have negotiated it out or parked somewhere else.
Sorry to interrupt. Have they taken a different stance depending on whether there's a balance between the parties? Like, would they be more likely to say, these are extravagant liquidated damages if, for example, it's a consumer contract?
Yeah, very much so. So consumer contracts tend to have a slightly different approach. A lot of the cases have been between businesses of any size. And they said, that if you knew about it, you negotiated. It wasn't hidden. It wasn't, hidden in the small print. So you were fully aware of this because you chatted about it. So therefore, you can't really back out of it. You might, under consumer legislation, it has to be transparent, because we know the Consumer Rights Act in 2015 changed, the whole balance between commerce and consumer, much more in favour of the consumer. So consumers are less likely to have liquidated damages provision, less likely for them to be upheld. But in terms of business to business transactions, the basic answer from the course is don't whinge, read before you sign. If you don't like it, don't sign it, rather than trying to wriggle out of it at a later point.
Yeah, that's probably where a lot of people get confused, because they read stuff online that's really a rule that's developed in a case that was with a consumer contract, when actually they're dealing with commercial contracts, and it's a different ball game. And really, correct me if I'm wrong, the courts they want to protect the freedom to contract, and if parties have negotiated a contract, like you said, they've agreed to the terms, well, tough.
Yeah, very much so, very much so. And you know what, it wasn't until the mid-19th century, about the 1850s, where the courts were prepared to intervene in commercial contracts at all, because they said men of business, and it was mostly men in those days, men of business should be allowed to transact on whatever terms, and we don't think there's any place for the court to intervene. They started to intervene, and sometimes it was about creating balance between big companies and the consumers, because the people started to use contracts really to bully consumers. So they introduced sort of balance and checks and all this kind of stuff. And then we ended up with some legislation, certainly in the UK, that helped to create some more balance. And that's been consolidated in the Consumer Rights Act. But generally speaking, in business-to-business transactions, the courts are saying, just grow up a bit. You can write whatever you like in your contracts. And once you've written it and agreed it, you're stuck with it. And that's kind of why I think simple contracts are really useful, because actually, rather than relying on your lawyers to read it and tell you it's a good contract, you can read it. Business owners, business managers, people who are actually going to use this contract to do projects can read it and understand it and get it. And I think it's so important to be able to have ownership and control of your business without delegating absolutely everything to specialists, because you might delegate your PAYE, your accounts, your IT, your cyber security, your legals to other people. You're left doing the bits that you love, but actually now your business isn't necessarily or entirely within your control. So I think simple, plainly written contracts that are easy and quick to read means that there is nothing hiding in the small print. All the phrases like liquidated damages are got rid of, so it means what it says. It's kind of the Ronseal test for your contract. Does it do what it says on the tin? You don't kind of feel embarrassed or about receiving it if you don't understand it. You don't feel embarrassed about sending it to people, because you're not saying, oh, here's my contract, I know it's really long, but just sign it and send it back, which is too many people's experience of contracts. So simplicity means that you've got the core things in there. You can decide what you think might be missing. You can see whether you really follow it, whether it does record what you've actually think you've agreed. And then you can just get on with doing the job that you want to do. And that's why we set up our businesses, is to do what we love. And actually contracts are kind of becoming a barrier, hurdle to doing it. Rather than facilitating that transaction between us, it's actually becoming a real barrier for most people. So I think we need to get away from contracts as being documents which prevent us doing what we love, and that ones that actually properly facilitate us, that help us to do what we really want to do.
For people who are interested in your concept of the 500-word contract, the idea of making your contract a much more manageable document, they can go to your website, they can check out these articles and resources that we've mentioned today. What for you would be the first step? Something that listeners could do literally today that is going to make a difference?
It's really simple, but you need to dig out the contracts you're currently signing and read them from start to finish.
Ooh.
And if you're not prepared to read them from start to finish, you've probably got a problem waiting to happen. Now, on 99 of your projects, nothing. It won't be important, won't be relevant. But it only takes one project for that contract to actually lose you tens of thousands of pounds, and for you to think, I wish I'd paid more attention. And too many people come to me going, I wish I'd known this before I signed this contract. And I want to avoid people doing that. So read the contracts. Don't read them all at once, one at a time. Take it slowly, but start to read them. Then when you read them and you don't understand things, particularly if you've written it, get some help or rewrite it, or think about how you would explain it to your partner, your children, and then rewrite it. bit by bit. But also, if somebody sends you a contract and you don't understand it, the best question to ask is not what does it mean, but what is it meant to do? Because a contract clause should have a purpose. It should have a meaning. It should have an objective. And the question is, what is it meant to do? Because if they can't tell you what it's meant to do, the next point you should make is, can we delete it? If they don't know, it may be because they don't understand their own contract either. So it might help them to improve their contract, but it'll certainly help you, because if you don't know what it does and they don't know what it does, it could be that you don't need it at all.
That's a very good point, because I think a lot of the listeners, most of the listeners to the show are non-native English speakers, and they're trying to learn the language of the law. They're working with contracts, or they're working with clients where they have to speak English or draft documents in English. It's not their native language. And this is difficult for people whose native language is English. It's doubly difficult for people whose native language isn't English. And I remember I had a student a while ago who came to me with an indemnity clause, which was a standard form contract that they'd got from the other side. She came to me and was like, I don't understand this indemnity clause. What does this mean? And literally, it was just like really long sentences. It did not make sense. It didn't make sense. And I think your point of saying, well, look, if you don't understand it, go back to the other side and say, could you explain this a bit more? What is this clause meant to do? Is a really good point. It's difficult sometimes if you're not a native speaker because you're worried that you're going to sound stupid. But the reality is that very often you're dealing with a clause that is just overly complex and actually doesn't make sense at all.
And one of the things I always say at the beginning of my workshops is, please, please, please ask the stupid questions, because there's a Chinese proverb, whether or not it's an actual Chinese proverb or a fake internet Chinese proverb, I'm not quite sure, and I wouldn't like to say. But it's better to ask a question and feel a fool for 5 minutes than it is not to ask a question and be a fool for your lifetime. It's the line of least resistance is just to accept bad drafting, whoever sent it to us. And we believe that it's our fault if we don't understand it. But the truth is, and one of the things I say on my blog is, the purpose of communication is not so that you are understood, is so that you cannot possibly be misunderstood. And if somebody sends you something that you don't understand, they have failed, not you, they have failed. So it's really important that we have people who ask the questions, because that's the only way people will realise that their writing only makes sense in their own head. And if it only makes sense in your head, that's not good enough. If I used my twin talk to write contracts and sent it to you, Louise, and you said, well, I don't really understand what any of this means, then that's my fault, not yours. Okay. It's easy for us to kind of go, oh, well, I ought to know. Well, why? Why should you know? Why? It's not obvious. Law isn't obvious. And even amongst specialist lawyers, it's not obvious. I've seen contracts that are so badly written. People send them to me for me to sign, and I have to say, I can't sign this. This does not make sense. And then quite often they say, well, everybody else signs it. I say, I don't care that everybody else signs it. I want to understand the contract that I'm signing up to, because I need to know what I have to do for this project to be a success for both of us. And if I don't understand it, how can I possibly help it to be a success? You know what? Let's get back to brass tacks and go, well, you can send me a big pile of gobbledygook and I can sign it, or we can just write something that both of us understand our role, understand what success looks like, and understand how we're going to get there and what happens when we have a couple of detours on the way. That's it. That's what we need our contracts to do, to focus on the important stuff. There's a whole load of research by the IACCN, the International Association for Contract and Commercial Management, and they've looked at what gets negotiated and what causes disputes, and they don't match. So we negotiate the wrong things, we write the wrong things, we dispute things, but none of this is joined up. There's no sort of feeding back in and making things better. It's all just making things longer and more complicated and more transactional. You know what? I think if you asked us 150 years ago where contracts would end up, in those days, it were maybe written on a ticket, back of a hotel door, on a slip of paper. nobody would have predicted the thousands and thousands of pages that get wasted writing contracts, which frankly nobody reads, uses or understands.
I'm a big fan of the concept of minimalism in my own life, although I try to follow it, but not 100%. So this concept really appeals to me. And something that I want to ask you about is the objections. We spoke a little bit about this, like in terms of you might get a bit of backlash, but what are the objections? How do you respond to them?
So one of the objections is you can't write it in 500 words. So that's why I ended up writing the books, because people thought that you couldn't. I don't think 500 words is a panacea. I don't think it's the answer. I think this is a challenge to try and help people to think about contracts as a tool of building business and building trust and building relationships. And rather than it being sort of a Bible that gives you all the answers, it's kind of a list of, it's a 10 commandments as opposed to the whole Old Testament, New Testament and everything in between. So I think some of the barriers as well, if you take stuff out, you've got risks. It's like, well, yeah, but there's no such thing as a watertight contract, because otherwise the courts would be less busy with interpreting the ones we've got. So there's always seems to be a reason why you can't do it. But actually, if clients love it and clients can do business quicker and easier, and one of the things I've always said is, well, think of all the time, effort, energy that's put into negotiating, drafting, amending, reviewing these major contracts that we currently have. Why don't we sign something simple that looks a bit like a heads of terms and then put all that time, energy and effort into the transaction itself? Wouldn't we have a better result? Because actually, rather than preloading it with a whole load of legal time, energy and effort, we actually using that same energy and effort and money and everything else to actually build better relationships at a good level, at the right level, between people who matter, let's face it. They're the ones doing the project. The fact that the lawyers quite like each other now because they've got a contract doesn't really help the companies whatsoever. So there were a lot of lawyers. And in fact, the first person I sent it to was a transactional or disputes lawyer in construction. And she came up with so many objections that I nearly hid. It took me a while to get back out from under my rock. And I got over myself. I said, you know what? It's not perfect. It's not the answer. It's an answer. And if you use it with the intent it's designed, which is not as a watertight, bomb-proof contract, but as a way of building relationships, starting the conversation, then that's better than starting from something massive and trying to cut it down, starting from something small and just building up with what you need for your transaction.
I think it's also a really nice way for law firms, lawyers to differentiate themselves from the old world. Like, especially now, the world has gone through this unprecedented, I hate to say that word because it's like the buzzword at the moment, but this time that, we haven't experienced before, at least, in our lifetimes. And we're coming out. Things really have to change. And moving forward, listeners out there, if you are thinking of, well, how can we differentiate ourselves from the competition? How can we be more efficient and more valuable for our clients? Well, you've got the answer here. It's not, as Sarah said, this panacea. It's not going to solve everything. There are always going to be problems. Nothing's perfect. However, this is a really, really good step in the right direction to making your contracts more understandable, more simple, more efficient, and more controllable. So I am definitely right there with you, Sarah. Great. And you mentioned the IAC, is it the IACCM? I don't know how many C's there are, but I know the website that you're talking about, and I will leave a link in the show notes. I think I've referred to it before on the podcast. Are there any other resources that you'd recommend people check out?
Well, if they're particularly interested in doing something more visual, thinking about different ways of presenting contract information that's not just walls of text, which is what we've become so used to. Even when we pick up our smartphone and look at an app, that's all we get is a wall of text. The IACCM, so 2 C's, has a contract design pattern library, and I'm one of the contributors to that. And it has lots of different ways of giving information in a contract which may stimulate some ideas of how you in your business could do something different. And particularly, one of the first companies I worked with was a t-shirt design company. They were brilliant because they wanted to show their abilities in design in doing their terms and conditions. It was revolutionary at the time. The idea that you could have images and icons and layout that was white space and all this kind of stuff was quite unusual. This was quite a long time ago. But it really got me thinking that actually, if we don't want to bore people into submission, we want to draw them in, making it more visually attractive, making it easier to follow, making it easier to find information is really important. So it's a really good place to stimulate some ideas for how you could present the same information, but in a different style. So once you've got your content sorted, you can then jazz it up a bit, shall we say.
You've got a template of that contract, I believe, on your website about the t-shirts, and with a video, which, and I've talked about this a lot in the podcast, that these visual contracts, they're not just for small-scale consumer contracts. People like Shell, big commercial companies are doing it. You're not going to be totally the only ones doing it if you decide to take on this, but you will be following the trail of innovation. So I'll leave a link to that as well in the show notes. So good. I think we've probably covered, well, we certainly haven't covered everything. I could probably go on talking to you forever, but we've certainly covered quite a lot today. So thank you, Sarah. Super, super helpful. Thank you.
You're welcome. It's been a pleasure.
Good. And for listeners, as I mentioned, I'll leave all of those links in the show notes. Do check them out. Do contact Sarah if you've got questions, if you would like to do some training with her. You can contact her, as I mentioned previously, on her email, sarah@500words.co.uk. Get in touch with her on LinkedIn. She's always posting helpful stuff. And hopefully you'll be on the path to improving your contracts. Buy her book. Okay, so thanks for listening and see you next time.
Thanks for listening to the Study Legal English podcast. If you really want to get ahead, why not become a member and gain access to many learning resources? Visit studylegalenglish.com/pricing.